So I've asked John Armfield, who's a great advocate for the cause. I was his junior, I think, in presenting a case for retaining the oath of allegiance, wasn't it? Or was it the coat of arms?
The coat of arms. We gave evidence before us
yes. And I must say, I sat there completely enthralled, and I went in 100% in favour of keeping the coat of arms. I was then, when I left, I was 150% in favour, having listened to John Armfield presenting the case.
So which coat of keeping our current coat of arms?
No, we used to have the royal arms in the courts.
In the courts, that's right.
And then the state government legislated to remove them and use the state coat of arms.
In some courts, I've noticed that they've still kept some of the royal arms, but not in many anymore.
They kept them if it were physically impossible, or it would damage the heritage of the building and so on. But they got rid of them in a lot of places. They dumped some, I think, which is a terrible thing, really, and completely pointless. But it shows you the pettiness sometimes of people in wanting to continue something like that.
Like abolishing the appointment of Queen's Counsel.
Exactly.
Yes.
That's the worst.
And why hasn't it been restored in New South Wales? You've got it in Victoria,
They've got the option.
not in New South Wales.
Well, I think in New South Wales as well, they've got
Queensland
the option now. No, they don't?
Don't get me started. Okay.
No, Queensland and Victoria, and also Tasmania
Yes.
and New Zealand.
Well, maybe we should write to the Attorney General.
No, right to the Bar Association.
I think you've got to wait till the Attorney General in New South Wales changes.
No, the Bar Association.
Oh, no, but I think if the Attorney General changes, it'll make a big difference.
I've read an article somewhere about the recent elections in the. Somebody wrote an article in the Australian about the elections to the Bar Council.
Man called Phillips.
Good. Well, so we have a reformed panel. It's our final panel today, and I was going to welcome Keith Winchottle, who's so apologetic. He has written some marvellous books. His latest book, which I brought along because I thought I'll get him to sign it, is The Persecution of George Pell. And it's an excellent book on the presumption of innocence and all of the safeguards that we normally have in criminal trials. He also has written on what Mr. Coleman was mentioning in relation to Indigenous matters, the fabrication of Aboriginal history. He's written 2 volumes of a 3-volume work, which is very interesting. The breakup of Australia, the real agenda behind Aboriginal recognition, Quadrant in 2016, and this book, The Persecution of George Pell. He's not a lawyer, but I think it's a very readable book. The man who runs the Sydney Institute,
Gerard Henderson.
Yes, Gerard Henderson, is just releasing his. I think Margaret Cunneen is launching it tomorrow evening.
Tomorrow night.
Yes, and that will be very interesting. So Jeffrey Phillips is here, who's been a long-standing supporter of the Crown in Australia. I remember being with you in a debate at the University of New South Wales against Malcolm Turnbull. And do you remember what happened when you offered your your hand to Mr. Turnbull? You went to shake his hands?
He called me a scoundrel.
And said it wouldn't be appropriate. He wouldn't shake hands. This was before, we were all in a private room before the debate, and Malcolm arrived with his team at the last minute. They swept in grandly and then refused to shake your hand, which I thought was rather petty. Jeffrey specialises in industrial relations law, employment law, and Fair Work law, all of those related laws. He's the co-author of the legal textbook, Unfair Contracts in New South Wales. He's writer and editor of a number of Thomson Reuters publications, Quarterly Journal, Workplace Review. He's appeared on both sides in the industrial jurisdiction, in the Federal Court, the Supreme Court, the District Court, and the Chief Industrial Magistrates Court. He has a large advice practice and has appeared for a number of bodies, both as a barrister, but acting in a pro bono status. And John Armfield, as I've mentioned, is a great supporter of the Crown, constantly will be reliable in presenting cases concerning the Crown and presents them so superbly. So what we were going to discuss today in particular is one of the themes, which I thought was appropriate, the presumption of innocence, which I think is seemed to be under challenge in the Pell case, and it seems to be under challenge in relation to the soldiers who were charged or were under threat of being charged in relation to Afghanistan. And it seemed to me, since we are supporters of a constitutional system, do you think it's possible to argue, since the High Court has found that there is a separation of powers in the Constitution, is it an inevitable consequence, is it an implication of the separation of powers, that those standards which we have expected for so long in the criminal field, that is, that a case be proved beyond reasonable doubt and the presumption of innocence, should those be, are those really almost of a constitutional nature?
If I could just start that by just saying this, that every generation, in my view, needs to protect the freedoms which the previous generations have won. And it's surprising how much our freedoms can be lost if every generation is not vigilant in protecting them. And with the presumption of innocence, that is one of the freedoms which has been around for a very long time,
put it on.
and it's there for good reason. With respect to the sorry, if you don't mind. Sorry about that. I mean, ultimately, with the Bell case, the High Court sorted things out. Because criminal trials are probably the final bastion of where the presumption of innocence is important. In that, you do have a right to remain silent. The prosecution needs to prove its case beyond reasonable doubt, which is a high standard of proof, and that needs to be done on the basis of admissible evidence. The High Court is there ultimately to set aside judgments from courts below where they get it wrong, and that's precisely what the High Court did in that case with a unanimous decision. I think, though, the presumption of innocence is more under attack these days in what are called lesser tribunals or domestic tribunals, which are not governed by the same standards of proof, not governed by the rules of evidence, and oftentimes populated by believers in the tribunal's very purpose. I think you may have, over the last few years, seen a lot of work which Bettina Arndt's done in relation to universities, and she's done it in that area where I think there are some major problems, and I don't think it was Mae West that said it, but it was one of those old great lines that, when asked about sex, I think she said sex is here to stay, and most of the problems which seem to be happening in these domestic tribunals or in universities relate to sex, and it even has extended even further than universities. The presumption of innocence doesn't seem to apply at universities for people who have been the subject of a complaint of a sexual nature. The universities seem to act peremptorily and promptly against the accused, and sometimes the accused is either thrown out of the college or is not permitted to go to a course or is not permitted to graduate until some internal inquiry is conducted to determine whether or not the complainant's allegation is correct. And these internal university tribunals often do not understand the rules of evidence, do not understand the proof which is required in serious matters like that. Now, the High Court, in a famous case in the late 1930s called Brigginshaw and Brigginshaw, set out the standard of proof which is required in relation to matters which are not of a criminal nature, but where people's careers are at stake, their reputations are at stake, where their livelihoods are at stake. And there's a famous passage in Brigginshaw which talks of that very issue, and it's by probably one of Australia's greatest judges, Sir Owen Dixon, and he says this: it's not enough that the affirmative and allegation is made out to the reasonable satisfaction of the tribunal, and this is kind of talking about where the matter is not of a criminal standard, but reasonable satisfaction is not a state of mind that is attained or established independently of the nature and consequences of the fact or facts to be proved. The seriousness of the allegation made, the inherent unlikelihood of an occurrence of a given description, or the gravity of the consequences flowing from a particular finding are considerations which must affect the answer to the question whether the issue has been proved to the reasonable satisfaction of the tribunal. In such matters, reasonable satisfaction should not be produced by inexact proofs, indefinite testimony or indirect inferences. Now, one of the greatest travesties in recent times, in my view, has been what happened to Christian Porter. I mean, Christian Porter's career has been destroyed perhaps by two things. He was destroyed by an allegation which was clear hearsay. The person against whom it is said he committed an act was dead and could not give evidence, so the Court of Public Opinion relied upon hearsay. Hearsay is never a good framework to decide anything as serious as a person's career. And Christian Porter's other mistake or problem for him, the dangers of defamation actions. Ultimately, anyone who's come to see me and wants to sue for defamation, I've counselled them against it because of the very inherent dangers involved, unless it is clearly beyond doubt that there is a massive defamation being caused against you. And unfortunately, Christian Porter's career as a politician is over. And I think that that's one of the major problems which when you look at the modern day and particularly woke culture or cancel culture. Cancer culture is a cancer in our society. Of that there can be no doubt, where people's livelihoods on social media can be destroyed. Now that's probably a long-winded answer to your perhaps not so long question. I believe I've got some other things to say as well, but obviously we've got a bit of time to deal with it.
What is the rest of the...
Can I make a comment about Christian Porter? In my opinion, one of the great failures of Morrison was not backing Porter when he relied on Crown funding to support his defamation action. How else could any normal person bring a defamation action against the ABC, which has public funds and almost unlimited, it would seem, to defend itself? There was a real imbalance between Porter and the ABC, which was corrected by public funding, which was secret. How could he possibly be influenced in any decision he made as Attorney General by a donor to his crowdfunding who was anonymous? Impossible. And yet when the ABC and the opposition took up that point that he should disclose his benefactors with crowdfunding, Morrison didn't back Porter. He should have. To provide an even playing field between the ABC and a politician whose career is in jeopardy. Now what happens? They can now libel any politician and get away with it because they can't afford it with their own resources and they can't rely on crowdfunding from the public. It's a terrible result, which the presumption of innocence would have corrected.
I'd just make this observation. I've never practiced in the realm of criminal law, but in one of my other lives I was an honorary legal officer for a particular organisation. And I remember very well when the Royal Commission into police activities and other Royal Commissions was held, various people were called before the Commission and it was alleged that they had been guilty of various misconduct, including allegations like being a pedophile or engaged in things like that. And obviously these are very distasteful allegations and they are things which the people who are accused of them are immediately pariahs in society. And I'm certainly not justifying any of that conduct or defending it, but I well remember on one occasion the person who was in charge of this organisation said to me, if one of our members is called before the Commission, I want you to ensure that that person is immediately expelled. And I said straight away, I said to the person in charge, I said, well, that can't happen. And he said to me, well, you are justifying people who are engaging in this type of conduct and you are defending them. I said, no, it's very easy to make allegations. If an allegation is made and it is proved in a relevant court, then obviously I, as the responsible officer, would lay a complaint against them and they would be under our rules of our organisation. They would have been removed for inappropriate behaviour. But the point that I made to this gentleman was that unless and until it was established, we should not take steps. That was met with a great deal of resistance, but ultimately the advice was accepted. And the basis on which the advice was given was, one, there is a presumption of innocence. Secondly, as I said to him, much to his shock, I said, well, it would be very easy for someone to go to the Royal Commission and say, John Armfield did this. Are you saying that in a practical sense, the onus is then reversed and I need to disprove it? He said, oh no, he said, we know you, you wouldn't do that. I said, well, I said, how that applies to everyone. It's very easy to make allegations. It can destroy people's reputations. It can destroy their livelihood. So, as I say, whilst I can't claim any knowledge of the criminal system because I'm not practiced there, I can certainly say that two things. Firstly, it can do a great deal of damage to people, just the mere making of an allegation, because there are, unfortunately, members of the community who take the view they wouldn't make the allegation if it weren't true. There are people in the community who think that, which of course is quite wrong, because one of the things you find out in legal practice is that many allegations are motivated by malice, unfortunately. And I think the other thing is to remember that even people who may, or it's alleged, may have engaged in activities which are socially unacceptable are entitled to have their matter proved and to have a proper process. And even though we may strongly deprecate the particular conduct, we should always make sure that they have a right to representation and due process, because that is one of the very fundamental things that our system preserves. And as Jeff has said, it has been obtained at great cost, and we in this country are heirs of that legacy, and we need to protect it and be very vigilant about it.
I was surprised by two things in the Victorian Court of Appeal. Remember, Pell was found guilty in the lower court. He appealed to the Victorian Court of Appeal, 3 judges. I was surprised that 2 of the judges didn't seem to apply. I don't think that they even knew that there's a presumption of innocence. To summarise their judgments, they seem to be saying, believe the victim. It seemed to be the trend at the time, which was, you must believe the victim. The other thing that surprised me was when it went to the High Court. I wasn't surprised that the High Court quashed the verdict. Wasn't surprised by that at all. I was surprised that it was a unanimous decision. I thought somebody will dissent, but I was very pleased that it was a unanimous and therefore very strong decision. Were you surprised, Jeff, that the Victorian Court of Appeal, 2 of the judges of the Victorian Court of Appeal, seemed not to apply the presumption of innocence?
Look, with respect to some judges, I'm not surprised about some of them at all, because those 2 judges should have deferred to Justice Weinberg, who was a former Victorian Director of Public Prosecutions. Commonwealth, I beg your pardon, Commonwealth, who really, I've been corrected on appeal. Yeah. The other 2 judges, I don't think really had much of a criminal practice in their past lives, and so they really didn't understand what was at stake. But my second point is, judges too can be swayed by public opinion. There's some judges who are not bright enough or smart enough to actually put out of their mind what's going on in the public. And of course, George Pell ultimately was on trial for the sins of the church, not his own, in my view. And that ultimately is a major problem, because it's a lynch mentality. Oh, you're one of them, therefore you must have done it. And whereas Weinberg, applied the principles which should apply to people who are against him, the most hideous crimes of murder or rape or whatever, that such a person requires the presumption of innocence to be applied and the proper rules of evidence and the proper proofs to be provided to them. And George Bell was, and that's why the High Court was quite easily able to, in a unanimous way, overturn what the Victorian Court, Appeal Court did.
When I was in Melbourne on one occasion, I went to St Patrick's Cathedral and traced the steps, as it were, but as far as I could go. I couldn't go into the sacristy, but you could see how long it would have taken to come down. And had he been doing what the evidence said he did, that is, he acted like an Anglican clergyman and farewelled everybody and spent time saying goodbye. And then when you were aware of what he was wearing, his vestments, you would have realised that it was impossible for him to have committed the offence of which he was charged.
And even worse than that, the Victorian police were told of witnesses who could have given exculpatory evidence, and they weren't called. And that in itself is a massive error, and it in itself is a crime, because prosecutors need to call all relevant evidence. And there was that Monsignor, I think, was the one who should have been called, was not called. And I think that there's prosecutorial either incompetence or misconduct when witnesses who are material to the fact aren't called because they don't support the narrative. Prosecutors should be indifferent to the result, and ultimately that's the system.
My question is, if there is a separation of powers in the Constitution, which is implied, does that also mean that the standards which we assume will always apply in criminal matters are also part of that separation of powers? Can you read that in the Constitution? The High Court read into the Constitution, for example, that you can't close the rolls on the same day as you're calling the election. Remember that in the famous case where they let a lot of names onto the rolls? They said that's in the Constitution, but you find it very difficult to find that in the Constitution. Can you read something like these standards being part and parcel of the constitutional system?
I don't know about that. I don't think so. I mean, I think that's kind of getting into the area of the Bill of Rights area, I think. I mean, there is the Constitution, which has certain roles, and there's other aspects about our system, which is the common law, and there's also other aspects, which is the statute law within the states, and with respect to whether the presumption of innocence is something to do, a constitutional issue. They're more like that's more like a US Supreme Court sort of issue, not so much ours. I think it really is it's a complicated question.
There are examples in Commonwealth legislation of reverse onus on the accused in tax legislation and customs legislation. Some instances, averments in the prosecution and indictment are treated as prima facie evidence, which has the same practical result. These provisions have never been challenged as being unconstitutional in the history of Australia and the Commonwealth.
David, do you mind if I just make not quite the same point, but an allied point which Jeff has mentioned? He talked about the importance of the impartiality of prosecutors, and I'd just like to say this. Many of you may remember Sir Henry Winnicky, who was the Governor of Victoria and also had been the Chief Justice. And I think previously, I may be wrong in this, I think he'd been the Solicitor General of Victoria.
Yes.
A very distinguished, great man. And in his biography, there's a passage where when he was the Solicitor General, he appeared in, probably was called the Full Court of Victoria in those days as opposed to the Court of Appeal, but he appeared in a matter against a man who was self-represented, who'd been convicted by a jury. And this man was very inarticulate, not able to present his case. And the judges were about to chuck out his appeal. And just as they were about to do so, I think it was Sir Edmund Herring was the Chief Justice, Sir Henry Winnicky said to him, he said, "Before Your Honours determine this appeal, there are matters that I must draw to the court's attention which dictate that the appeal must be allowed." And he went on to enumerate matters of unfairness which had taken place at the trial and evidence at which had not been called, which is the point which Jeff's making. And Sir Edmund said to him, he said, well, we're very grateful to you for drawing this to the court's attention, because but for these matters being drawn to our attention, we would have dismissed his appeal, and a man who, whether he was guilty or innocent, who knows, but the evidence on which he was convicted was not safe. So I think the point that I'm making is it's very important that the people within the system understand their role and they adhere to it, because judges, quite rightly, rely on barristers. Barristers have great privileges as advocates. They can't be sued for negligence. They can't be sued for defamation, for what they say in court, but they have very great responsibilities for the administration of justice. And judges need to be able to rely on what counsel tell them as being, at least to their knowledge, truthful. And if there are matters that should be brought to the court's attention, to be able to rely on that they will. So I think part of this is it's important to engender in the system a concept of role and obligation, because whether it's something which is in our constitution, whether there's a prediction, which I personally doubt, I think what is as important is that we engender a proper understanding of responsibility, so as the system works and the people who are there, because the system's only as good as the people, that the people who are administering it know their obligations and they fulfil them. And that, what I've just mentioned, is a classic illustration of a man who was, went on to become the first Australian-born governor of Victoria, whose son later became the president of the Court of Appeal, John Winicky, who I knew, and actually by drawing it to the court's attention, made sure that someone's liberty was protected.
Nick Hobson, who handled all the registrations, who's had to go, who's the treasurer of ACM. He was an officer in the RAAF. He was Sir Henry Winnicker's very long term. He was his official secretary and learned a lot of vice-regal practice from him.
I mean, barristers aren't, particularly barristers have special roles to play in court, and we're not there to be the cat's paw of the client, not there to be just their mere mouthpiece. We need to only put proper submissions, and I've been in cases where I've been instructed to put a question which I thought was inappropriate or scandalous, and I've said, oftentimes you might see, the judges can see that on occasions, perhaps a very vigorous debate going on between counsel and the solicitor and perhaps the client there, and oftentimes that is when there's instruction which counsel has decided, well, that is an inappropriate instruction, I'm not going to do it, and you often can see things that, and I've returned a brief in the middle of a conference because of something the client said to me about what was going to happen about a particular doc, and which was damaging to his case, and they're the sort of things where you've got to exercise that professionalism, which is not win at all costs. It's not a business. It's meant to be a noble profession, and if the client's misbehaving, or even the solicitor's misbehaving, and that can happen on occasions, you're presented with those sort of ethical concerns and considerations which you need to pursue. That's kind of outside the presumption of innocence, but it was something which John touched upon, and about prosecutorial appropriate behaviour.
Can I make a point about the presumption of innocence? Undergirding it is the imbalance in economic power between the prosecution and the defence. If the defence has the onus of proving their innocence, they might have to call witnesses from interstate, which they can't possibly afford. Whereas the Crown prosecutor has the resources available to present the whole case properly and enable a proper verdict to be reached. An onus on the defence would be tantamount in many cases to automatic conviction, because they couldn't afford to get subpoena witnesses from interstate or overseas or elsewhere in the country, elsewhere in the state, and just rely on his own evidence, which might not be believed. Whereas if the independent witnesses were called by the prosecution to prove guilt, they may prove innocence. The imbalance in economic power between the prosecution and the defence undergirds the presumption of innocence. It's needed to counteract the different imbalance in economic power between the prosecution and the defence?
Keith Windshuttle, in his book on Pell, at page 378, quotes Barry Cassidy, ABC journalist and former host of Insiders, saying, "The High Court has found there was not enough evidence to convict. It did not find him innocent. You are then entitled to maintain your view, and you are under no obligation to apologise for holding those views." He was addressing ABC journalists on this. And Keith then goes on to say, "This is one blunder poor Barry will not live down, but neither was he the only one to display his ignorance in public. Justin Quill, a media lawyer, wrote an opinion piece for the Herald Sun that published the same line. The High Court did not find Pell innocent, as some commentators have suggested. Sure, he gets to walk free, but that doesn't mean the court found the victim was lying or that Pell was telling the truth, only that the jury should have found there was about reasonable doubt Pell was guilty." And he goes on to say, "A cadet journalist covering his first court case might have made this mistake. To find such a misunderstanding in the work of a veteran like Cassidy or the legally qualified Quill makes you wonder. In our legal system, the presumption of innocence means what it says. Anyone charged with a crime is presumed innocent until found to be guilty. We have no such indefinite judgment as in Scottish law as not proven. As you're not, as Cassidy maintains, entitled to maintain your view that Pell was once guilty. To do so publicly would be to defame him. A decent person who made this error would apologise, but not Cassidy of the ABC." Is he right?
He is right.
Yeah.
Well, that's reassuring. We had another, if I may go to another issue, the fundamental issue of the conference was the restoration of constitutional government in situations of emergency, as there was in wartime. And what Ken's excellent opinion, which is on the front page of our website, effectively says, and Ken will correct me if I'm wrong, that the checks and balances that normally apply, that is, in relation to subordinate legislation, that it be presented to the Executive Council for what I would call an audit of process, and that it be tabled in the Parliament, and that either House be entitled to scrutinise that and to disallow it if it feels that it is inappropriate, applies. And we should be concerned as an organisation committed to supporting, protecting and defending the constitutional system. We should be concerned that this situation has arisen in Australia. Any views on that, gentlemen?
Can I ask a question? Because there's one thing I'm not sure about in this area. I've not seen the legislation which allows ministers to issue various orders. My almost lay knowledge suggests to me that if a public health order or a different order is issued by a minister, it being presumably made under some regulation of a piece of legislation, that you could attack it on the basis it was made ultra vires, which means beyond power for the non-lawyers, or some other administrative ground. But is the major criticism not so much that you can't attack it? You can attack it in court on administrative law grounds, but you don't have public scrutiny in Parliament, whereas if a regulation is as I understand, if a regulation is made by the Executive Council, there is a power of disallowance by either House of Parliament, and that can be the subject of debate. Is that the major, I suppose I should be asking Ken, is that the major difference and criticism, or is there something else that we should be aware of?
There's two checks and two balances. The first check and balance is that the Executive Council, the Minister proposing the legislation, subordinate legislation, has to show that it's valid.
Right.
Point to the power and its proper exercise of it.
Gradually this has been whittled away by legislation. There was no legislative obligation on in any of these cases, in most of these cases, to bring it before the Executive Council. But there was a time when this would be considered to be the normal thing. The legislation would provide that, but foolish upper houses have allowed legislation to go through which has taken away what would be considered to be the normal thing. And this new legislation in Victoria provides for scrutiny by a government-controlled committee.
I mean, there's been a lot of talk over the years that school children should be given civics courses, that is, courses in our governmental structures and our history. I think parliamentarians should be given it. Because I think a lot of them have no idea what the system's about. I don't think there's any formal education involved when you're elected to Parliament in order for a person to understand the system. And someone recently told me about a New South Wales state government minister who said to my friend, some of these judges are making weird decisions, we've got to get rid of them. And now, of course, that is a complete misunderstanding of the independence of the judiciary. They are there. If you just can't get rid of them because you don't like them. But he had this view that they were like public servants; they could be sacked at will. And this fellow was a minister. I'm not going to name him, but I mean, it's just extraordinary that they did not understand. And likewise with things like delegated legislation, it's it should be subject to the scrutiny of the Parliament, particularly when the public health orders. In New South Wales, they kept changing every week. I mean, it was very hard to keep in touch, to actually comply with them, as to how and particularly when we had the areas of lockdown where you couldn't move outside that local government area. It was very complicated.
Well, we had the famous situation in New South Wales where the construction industry was closed down for 2 weeks and it cost 1.4 billion. And the chief medical officer said she didn't give advice to do that. So it was closed down presumably for health reasons.
Police weren't consulted either.
Yes.
Section 7 of the New South Wales Public Health Act enables the Minister to make orders and give directions where he considers on reasonable grounds that an situation has arisen which is or is likely to be a risk to public health. You have to show the Governor the reasonable grounds on which this power is being exercised. However, Section 8 says if a declaration of emergency is made, all that's swept away. The Minister can act without having to having to show reasonable grounds, having to prove it anywhere. And there's no obligation to lodge it in Parliament and have it subject to disallowance. So it's an unreviewable power. And it can create criminal offences with fines and imprisonment. No checks and no balance. No need for reasonable grounds. No need to show it to anyone else. Just act. If a declaration of emergency is made, that's not reviewable either.
Well, just coming back to a point that David Flint made, he referred to Sir Guy Green's lecture on the role of Governor, and some of you may or may not have read, there's a very excellent lecture that Sir Paul Hasluck gave on the Office of Governor-General, and in it he spoke about the role of the Governor-General as what we've loosely called today as a auditor of executive actions, and different Governors-General have taken different approaches, but Hasluck certainly took the view, which I would have thought was the proper view, that a minister who wanted a regulation made by the Executive Council had to prepare a minute in advance of the Executive Council meeting, which identified the head of power on which the regulation was based, a précis of the reasons why the regulation was appropriate, and also obviously a draft of the regulation which could be adopted. And it seems to me that that's a very important thing, and in a recent edition of the New South Wales Bar Review, which I gave to Professor Flint, and which probably Ken Handley and Jeff Phillips may be aware, that it was interesting to read of some of the dealings between Mr Whitlam and the then Senator Murphy and Sir Paul Hasluck, where they in effect suggested to the then Governor-General that he was obliged to act on advice and do things without any of those things, which was repelled by the Governor-General, where he said, well, no, you know, I may have to act on ministerial advice, but I'm entitled to know the head of power, I'm entitled to know what I'm doing and why. And it seems to me that that is a very important thing, which I'm not aware that there's a legislative requirement for it, but as a matter of conventions, it ought to be adopted in both the Commonwealth and the states in terms of making regulations to avoid a situation where either something is done which is wrong or it's beyond power.
It's part of the obligation to give advice to the Governor-General or the Governor. The advice must be given in a certain way.
What you get the impression in New South Wales during this crisis has been that the Premier decides on something, and the Minister goes up to his office, has the order drafted, signs it, and puts it in the Gazette. No, you don't go near the Governor. There's no audit. There's no separate process. There's no tabling of it in Parliament. Is that the way to run a state? A government?
Not the best way.
Can I just make one defensive comment? All three of us know the present Governor. She is a person of highest integrity, and I'm sure would do whatever were necessary if it were presented to her to follow the proper.
I'm sure.
I just want to say that on the
Yes.
record.
Yes.
I'm not want to sit here and give the impression that the incumbent, because I know her both professionally and personally. So the comment I'm going to make is directed to an office, namely that these are not personal things, they are matters of proper procedure, and the proper procedure should be followed. You might get to the same result, you might alter, nothing I'm saying ought to be interpreted as meaning that I think sometimes it was appropriate to issue orders. I don't want to give the impression of the reverse. That's not the issue. The issue is the process you follow, and the process should be the proper one, namely drafting the order, identifying what you're doing and why, so as to avoid the risk that something is done wrong and that people's liberties are interfered with in an inappropriate and arbitrary way.
Of course, the complaint is that the government didn't go near the Governor. The Governor's had nothing to do with all these health orders. They're purely on the part of the executive and the Minister.
The fault then is with our upper houses who've allowed legislation to go through which permits ministers to issue subordinate legislation without subjecting it to the scrutiny of the Executive Council or to the scrutiny of and the potential disallowance by either house. That's the problem. Should the state constitutions, should all state constitutions provide for a process? Obviously, you can't trust the parliaments to leave it in general legislation. We used to have the Acts Interpretation Act federally, which I think required the tabling of all subordinate legislation in the federal parliament and the potential disallowance, but they've whittled away that. Should there be some constitutional provision requiring this?
It would certainly help.
I think you need to have a provision in legislation which sets down the process, because the risk is if you don't have a mandatory provision and you rely upon ministers to do it, the risk is it won't happen. And in a very different context, there's a very famous judgment of Lord Atkin in a case called, I think, Anderson-Liversidge, where he was talking about there the ability of a minister to form a view which might affect the liberty of a subject, and he made the comment that he, dissenting in the House of Lords, refused to uphold the validity of this regulation, saying that even though it was made during wartime, it was important that the liberty of the subject be protected, and perhaps, I'm paraphrasing him now, that they were the very liberties which were being fought for. So that all suggests to me that you need to have some enforceable means of making sure that the procedure is there and that it will be followed and that there are consequences. So, for example, if you don't follow the proper procedure, then someone can go to the courts and complain that this is not a valid regulation and it can be struck down on that ground, as opposed to having to invoke other administrative law remedies.
Can I go back to the presumption of innocence on an issue?
You certainly may.
And it deals with the report handed down last week by the Sex Discrimination Commissioner, which was a review of Commonwealth parliamentary workplaces. And one of the recommendations that Kate Jenkins makes is the establishment of a body called the Independent Parliamentary Standards Commission, which will have real power of investigation and providing sanctions on in the context of Commonwealth parliamentary workplaces. About 10 years ago, in a famous case in the High Court, Dyson Hayden dealt with the dangers of specialist tribunals, and he said this about, quoting an author, he says, "History teaches us to be suspicious of specialist courts and tribunals of all descriptions. They are usually established precisely because proceedings conducted in accordance with normal judicial standards of fairness are not producing the outcomes that the government wants. From the Court of Star Chamber to the multitude of military courts and revolutionary tribunals in our own century, this lesson has been repeated time and time again." And then Justice Hayden goes on to say this: "However, there may be, the appellants referred to in submissions, the danger of conferring jurisdiction to hear criminal proceedings on courts and practitioners which are unfamiliar with all the relevant rules. There's a related danger in that course in that the courts on which the jurisdiction has been conferred, while in some sense specialists, are not familiar with the relevant rules. Thus, a major difficulty in setting up a particular court like the Industrial Court to deal with specific categories of work, one of which is a criminal jurisdiction, in relation to a very important matter like industrial safety, is that the separate court tends to lose touch with the traditions, standards and mores of the wider profession and judiciary. It thus forgets the fundamental matters like the incapacity of the prosecution to call the accused as a witness, even if the accused consents. Another difficulty in setting up specialist courts is they tend to become over-enthusiastic about vindicating the purposes for which they have been set up." And then he says this: "Courts set up for the purpose of dealing with a particular mischief can tend to exalt that purpose above all other considerations and pursue it in too absolute a way. They tend to feel they are not fulfilling their duty unless all or almost all complaints that mischief has arisen are accepted. Courts which are preoccupied with special problems like tribunals or administrative bodies of that kind are likely to develop distorted positions." And that I think is the danger in this particular parliamentary tribunal investigating politicians. The only good thing about it is it's going to be in camera, unlike ICAC, where many people's careers have been destroyed on basically allegations as well. I think that's another area of specialist tribunals where we've got to be so careful in their establishment to make sure that the people who are put there, where real issues of people's livelihoods, careers and reputations are at stake, are fully independent and are also have people there who understand the rules of evidence and the process of proof, which I mentioned earlier about Brigginshaw. I think that's an area. Of course, I mean the Kate Jenkins report was no doubt activated by the fact that some aspects of parliamentary life in Canberra looks like Schoolies Week, and something really had to happen. But ultimately, when you have a problem, sometimes the cure can be worse than the actual complaint itself. When there's been real problems in Parliament House, and there is and look at the Brittany Higgins case, of course, that will be determined by a criminal court, as it should be. So that, but there are other matters, particularly in Parliament. It's very difficult to really see how a commission like that, if it, other than one set up appropriately with proper personnel, but as I said, the danger is they'll be looking for the error for which its purpose has been set up.
Has the Brittany Higgins rape case been prejudiced by the release of this report and by the adulation given by the Prime Minister and others to Miss Higgins?
That will no doubt be a submission made to the ACT Supreme Court in due course. Look, I think in matters like that, I think you are walking a very tight, narrow line when you start making suggestions as to the strength or otherwise of a case of a criminal nature like that, and could cause prejudice.
It was like the release of the report from Afghanistan, where the Prime Minister announced that it contained brutal truths. And then they appointed a body because they couldn't prosecute on the basis of the report. They then established a prosecutorial body, an investigative body to prepare the brief for prosecution.
I think the Prime Minister should be given a lesson in civics, particularly what he said about the Cartier watch in Australia Post. That kind of very broad statement, no doubt probably may have passed the pub test in the Southern Shire, but it certainly did it ended up being a lot of payout for the former CEO of Australia Post. It was a silly thing to have said. And of course nothing would have happened had it been a $5,000 bonus. Just it happened to be watches. It's a silly thing.
In our final moments, does anybody in the audience wish to make a comment on what has been said or ask a question? If not, I'll close the session and thank you so much for your attendance and your time and your wisdom. And that brings us to the end of the conference. And I thank you so much for being so valiant as to turn up, and hope that in the videos this is produced well, and that it shows there is great interest. I think that there's a very important message, which I think this panel was unanimous, that is, there's cause for concern about the situation of constitutional government, especially in emergencies. Thank you.